We've all heard recently in the news about the offense of driving under the influence of marijuana. The state legislature has not changed the drinking and driving laws because of marijuana. Our drinking and driving laws have been referred to as drinking and driving laws, when in fact the word drinking doesn't appear in that law. What that law states is that it is against the law to operate a motor vehicle at a time when your ability to drive safely is impaired by drugs or alcohol. You'll hear the acronym DUID. Well, that acronym is actually just made up to help those of us who practice in the field refer to a DUI case that involves drugs as opposed to alcohol. Make no mistake, it's still the same law, driving under the influence. Especially right now, driving under the influence of marijuana is a complicated case because we don't have any guidelines from the medical experts or the state legislature, for that matter, as to how much marijuana is necessary or needs to be consumed before one is impaired. Certainly we have medical marijuana users who are smoking on a daily basis. Does that mean that they can never operate a motor vehicle again? That would be unfair, because if that was true, then people who are prescribed antidepressants, Prozac, Lexapro, or people who take sleep hypnotics at night like Ambien, when people take those substances, does that mean that they can never operate a motor vehicle again? Certainly, if that was the fact, that the medical office that you go to for medical issues would be a place where you can lose your driving privileges if that was the case. The fact of the matter is, you can operate a motor vehicle when you are taking prescription drugs or smoking medical marijuana, so long as those prescription drugs or medical marijuana, for that matter, does not impair your ability to think clearly, does not impair your ability to operate a motor vehicle.